That is, my Lord, the challenge, as you know, is to the decision of the Secretary of State for Business and Trade. That decision was effectively in two parts, as you will have seen from one of the ministerial resolutions you looked at this morning. Firstly, to suspend the export of arms to Israel, but also to make an exception for the F-35 programme. The reasons for the latter were dealt with by the Divisional Court, and they were essentially the extraordinarily serious impact for the United Kingdom and for international peace and security of doing that. Those reasons were the subject of detailed advice considered by the Divisional Court from the Defence Secretary and from the Foreign Secretary. You will see the nature of the advice from the Defence Secretary in the judgment. If you have that, I'm assuming you will have that loose somewhere.
Yep.
In the judgment at paragraph 2. And that advice from the Defence Secretary was understandably accepted by the Secretary of State for Business and Trade, whose decision ultimately and legally it was. That advice is self-evidently a matter of judgment about profoundly important impacts taken, as the Divisional Court emphasised, by the constitutionally responsible and the constitutionally accountable actors. And it was for that reason, no doubt, that the court emphasised, as it did, the high hurdle that will be faced by any JR of that decision. See paragraph 10 of the court's judgment. It ultimately led to them refusing permission to bring the claim, not just refusing the claim itself. And you might like to write next door to paragraph 10, see also paragraph 207. But the advice didn't sit alone. It was supported by evidence, including closed evidence. See for more detail, if necessary, the judgment paragraphs 22 to 25 relating to the F-35 programme. That's why there was such concern. That's a helpful summary by the court. Of the difficulties and the reasons why the exception needed to be made, taken from the evidence, including the closed evidence. And see also in the judgment paragraphs 41 to 44, in which the court is concerned properly to characterise the true nature of the decision that was under challenge, the true nature of the F-35 carve-out. And we submit that they accurately did so, premising it on the basis it wasn't currently possible, see para 42, to suspend licensing of F-35 components for use by Israel without having an impact on the entire F-35 programme. And you see the quoted advice from the Defence Secretary on that point. They then go into why it was not possible, to the extent that they were able to do so in open, but they explained there that the detailed reasoning was explained in the closed evidence. You see that in paragraph 43, and then they characterised the nature of the decision, the true nature of the carve-out, at paragraph 44, which is of some importance, and we respectfully submit shapes quite a lot of what follows, as it were. The Divisional Court comprised Lord Justice Males and Mrs. Justice Steyn, whose expertise and experience needs no introduction in relation to the issues of principle that were being thought about in the judgment, including the interface between domestic and international law and the appropriate standard of review and how all of that worked. But they gave detailed and comprehensive open and closed judgments. They did so after a rolled-up hearing involving 4 days of argument between the 13th and the 16th of May of this year, by the claimant, by the defendant, and by 3 interveners who were permitted to intervene because of their particular expertise and ability to provide relevant evidence. They had the benefit, if that's the right way of describing it, of a 167-page skeleton from the claimant and an 86-page skeleton, shamingly, from the defendant, together with written submissions from the interveners. And they did it after considering thousands of pages of evidence. And as I say, after a closed hearing, at which it considered all of the evidence you've seen summarised. Against that backdrop, I just wanted to touch briefly on the shape of the argument before you today. The application for permission to appeal, as you know, was commenced by the appellant's notice of the 16th of July 2025, with effectively six grounds of appeal. You have them in the core bundle at pages 15 to 16. I don't invite you to turn those up, supported by an appellant skeleton argument, which you have in the core bundle at pages 20 and following. We then filed a short statement of reasons opposing permission on the 28th of July. You have that at page 631 of the core bundle, a relatively short 3-page document consistent with the rules. That application was then considered on the papers by Lady Justice Andrews, and her order was dated the 4th of August 2025. You have that in the core bundle at page 635 to 7, and she refused permission. And back to the significance of this. She refused permission on grounds 3, 4 and 6, adopting the appeal grounds, and she adjourned the application for permission, this being an application following a refusal of permission by the divisional court, as you know. She adjourned the application on grounds 1, 2 and 5 to an oral hearing. Last week, on the 1st of October, almost 2 months after her order, and 6 working days before this hearing, the claimant then served the application to reopen her decision on ground 3, and that was the application that you heard from about shortly before the short adjournment, and that's been adjourned to be considered at this hearing as well. You also have the Secretary of State's response on the 6th of October to that 52 or 53, 30, 20 application. It's at the end of that bundle. I'll come back to that. So what is before the court? What is before the court is firstly the application for permission to appeal on ground 1, relating to ground 8 of the underlying claim, the domestic foothold and the international law issues. Lady Justice Andrews' provisional view was that the application would, as she put it, face considerable difficulty in demonstrating there was a real prospect of success in appealing that ground, but adjourned it because of the importance of the issue that was raised. Secondly, you have the application for permission to appeal on ground 2, that was ground 9 of the underlying claim. That's essentially a challenge to the approach of the divisional court to the issue of the reception of customary international law into the common law, into domestic law. Lady Justice Andrews was of the same view on that as she was on ground 1. See paragraphs 3 and 4 of her permission decision. Then you have the application for permission to appeal on ground 5, was again part of ground 8 of the underlying claim. That's foreign act of state, and that also was adjourned to this hearing because Lady Justice Andrews considered it, as she put it, inextricably linked to grounds 1 and 2. That's paragraph 7 of her ruling. And then you have the application on which she refused permission to appeal on ground 3. So what is not before the court is first of all the application for permission to appeal on ground 4. That's perhaps of lesser importance. The court erred is that ground in, it was said, in characterising the appellant's challenge as requiring the court to rule that the UK must withdraw from a specific multilateral defence collaboration. That's gone. More significantly, perhaps, the application for permission to appeal on ground 6 has also gone. And that was, and I quote from the core bundle, page 16, the court, that's the divisional court, say the appellants, failed to give adequate reasons for its conclusion, which was in any event wrong, that the Secretary of State had adopted a tenable view of the international obligations relied upon by the appellant, and Lady Justice Andrews refused permission on that ground. Paragraph 15, that decision is therefore final, and the claimant has not sought to reopen it. So what is not being challenged is any suggestion that the Secretary of State was not, as it were, entitled in the alternative to the non-justiciability arguments to reach the tenable view that what was being done on the F-35 exception was consistent with international law obligations.
I wondered about that. So does that really mean that there is an aspect in which this is all academic because they're going to lose anyway on tenable?
That's exactly where it goes to. The only way they can win is, in the light of that, the only way they can win is by saying that the only standard is correctness. You see how the argument's shaped. You have non-justiciability. Alternatively, is normally the way the argument works. Yeah. Alternatively, if the court can get in and look at the international obligations and all the rest of it, it's tenable view. That's the Sales Claimant thesis and all of that. And then finally, correctness. So what they'd have to do is to establish, it's not enough for them to establish that tenability is the right test in the alternative. They have to go the whole hog and show that tenability was the wrong approach, even in the alternative.
Yeah, quite.
Yeah. So my lady is right. There is a very real sense in which it's academic.
Yeah. So it seemed to me that whether tenability was the right test or the wrong test was built into ground 6, but to be fair, the skeleton swam around a bit and bits of tenability came in elsewhere, but it did strike me that it was a ground 6 point, and that's not before.
Yeah, it's not entirely clear how it works. As I understand it, part of it is my learned friend Mr. Hussain saying, well, this is policy, and if it's policy, the court is entitled to rule as a matter of error of law and correctness, rather than tenability. But we say there's plenty of authority that supports in the alternative for not for wrong and justiciability. Or if this is a context in which the court will look to a degree, it in effect treats it as a material circumstance, not as an error of law, because the unincorporated international law does not become part of domestic law. That's the way the argument works. But it's quite important to remember how those stack up as alternatives, and then you've got that break with tenability, because the one thing they cannot challenge is any suggestion that it was up to
the tenable view of what international law obligations.
Exactly. So that's how you have the thing. And really, that's the punchline of going through all the what's in play and what isn't.
Sorry, I took your punchline then.
We like a court jumping in on the punchline. Anyway, that's the shape of the issues. I was going to turn first of all to ground 1, non-justiciability, if I may. Just pick straight in. The starting point is well known and doesn't appear to be terribly controversial. But the starting point is nevertheless important to emphasise, because you test the position first by reference to the general position, particularly if what seems to be being implied in the oral submissions that Ms. Cadfan made this morning is that all of these principles have collapsed into foreign acts of state. They haven't at all, it's our submission. There are discrete lines of principle, some potential overlaps between the basis for them, but there are discrete lines of principle that are involved here, and they're all of some real constitutional importance. So we start with the basic position, and the question that would then arise is whether it will be permissible to challenge the government's decision to continue the F-35 programme on the basis that allowing to do so would or might place the United Kingdom in breach of its international obligations. Is it open, put it another way, to a court to determine, in effect as a public law legal standard or constraint, that the government action would be or had been in breach of unincorporated international law? And we submit the answer to that is plainly not. The basic position is plainly not. And the reason for that is not very hard to find. It is because the UK is a dualist system. In other words, international law sits on the international plane and requires an act of incorporation before it becomes part of domestic law. Unincorporated international law is not domestic law. It isn't like a domestic statute or a principle of public law. It doesn't create, that's unincorporated international law, does not create any domestic legal rights or obligations. So it has no direct effect so as to create any such rights or obligations under national law. And that means that it provides, unincorporated international law provides, no basis for a judicial review challenge. It isn't the foundation for a public law ground. And the court cannot and will not, it's got no jurisdiction, to coin that phrase, to opine on the nature of any obligation it might create on the international plane. For a very clear summary of the case law that establishes that basic but fundamental constitutional position, see the judgment at paragraphs 72 to 82, citing a series of extremely well-known cases, beginning, perhaps it could have ended, with J.H. Rayner and the very well-known passage from Lord Oliver you find on page 77. A critical quote in the passage from Lord Oliver you'll all be very familiar with. It's really the last 7 lines on page 77. Quite simply, a treaty is not part of English law. That one, I'm sure, will echo with all the members of the court. But it traces that principle, that essential principle, through the Queen and Lions, which was the Guinness defendants coming back, having won in Strasbourg, pre the ECHR becoming part of domestic law, and being told that challenging their convictions was a matter of domestic law, nobody coming and saying the Strasbourg court had found for them in those days. And you see the way in which the principle is put, again, echoing the jurisdictional basis for this. If you go to page 79 and you look at paragraph 27 in the quote from Lord Hoffman's speech in Lyons, you see about 5 lines into paragraph 27 of that quote, and it's firmly established that international treaties do not form part of English law and that English courts have no jurisdiction to interpret or apply them, and then he cites J.H. Rayner. That theme and that language is then picked up in a succession of recent Supreme Court cases, all of which are to the same effect. In paragraph 75 of the court's judgment, you will see that the divisional court expressed this as a point of jurisdiction. Look in the second line on page 80. Domestic courts have no jurisdiction to interpret or apply unincorporated treaties, and they take that language directly from the judgment of Lord Reed in the SG case, paragraph 90. See the first sentence of that quote, using exactly that language, and they emphasise the same point about it applying both to the interpretation and also the application of unincorporated international law in paragraph 76 of the divisional court's judgment. To the same effect, they correctly then cite the Miller case. That was about whether we needed an Act of Parliament to leave the European Union, as you'll recall, and SC, in which the Supreme Court, sitting en banc, as it were concerned to set out how international law worked in domestic law, in particular in the context of the ECHR. And so that is all pretty familiar stuff. I just wanted to remind you of Lord Reed's judgment in SC, which they cite without giving a reference to the paragraph numbers in paragraph 77 of their judgment. It is just worth reminding you of that judgment, if I may. It's tab 24 in the authorities bundle. I'm not sure how many you've got, but tab 24, if you can find that. If you're on the page numbers, the page number I want is 1207. And this was the I want paragraph 74 at the bottom of 1207. And just to put it in context, there have been a succession of cases in which ECHR issues had been raised, including in particular issues about discrimination and justification for discrimination, in which claimants had sought to rely on a series of international conventions, including, for example, the UNCRC, Convention on the Rights of the Child. And the arguments that were being mounted were, under the ECHR, it's appropriate to take into account international law. If you take into account international law, if you can show that the facts equal a breach of that international convention, that supports a finding of disproportionality, effectively. And it was that they were determined to debunk in these paragraphs. So it's 74 really through to the end of 78, if you would. Can I just invite you to cast an eye down? This is a second en banc bill. This is a 7-person court. But there's a long line of authority to this effect. CND is the Campaign Against Nuclear Disarmament case in the Court of Appeal, another example, but a succession, all to the same effect. So the principles from which one starts are long-standing and well-established. Unincorporated international law does not confer rights or obligations. The courts have no jurisdiction either to interpret it or to apply it in the absence of some form of domestic incorporation. And in the present case, no one has suggested that any of the international law obligations relied upon by Al-Haq, summarised in the judgment between paras 47 and 67, had been incorporated, and indeed the appellants don't appear to quibble with that. So the remaining question from that starting point is whether action by government can alter that, in effect to create a jurisdiction that would not otherwise exist, to hold government to the unincorporated international legal standard, and in doing so to rule on what that standard means and how it applies. And Al-Haq's case on the appeal, and indeed below, is that the SELC, the SELC, provides a sufficient domestic foothold, as it's put, to enable the court to decide whether the F-35 carve-out is consistent with those unincorporated international law standards. And that is the argument that is dealt with in the judgment below at paragraphs 110 to 116 in particular. And the first point that we make, because it's perhaps a simple way of disposing of the matter, is that there was no domestic foothold, as it's put, as a matter of fact. That's dealt with by the Divisional Court in the second of their 3 independent reasons, and I emphasise independent reasons because of the judgment at paragraph 111, which makes clear that they are indeed independent reasons. But the second of them, which is dealt with at 113 and 114, is the point of fact. And we submit that this alone is fatal to the ground of appeal. It's clearly a finding of fact, which the court was self-evidently entitled to make. There can be no suggestion that there wasn't a basis in the evidence for that finding, or that there was some form of demonstrable misunderstanding of the evidence. The court is well aware of the threshold for disturbing a finding of fact made by a court below, and the appellant doesn't even allege that threshold is satisfied. If they had done, or to the extent that the attempt is made, the allegation would be hopeless. The Divisional Court reviewed the evidence and reached a view on it. They found at 113 to 114 that the contemporaneous documents clearly demonstrated that the SELC had been disapplied in its entirety on the basis, unsurprisingly perhaps, of the wholly exceptional situation that existed in relation to F-35s, because of the way in which that programme operated and was set up. And we respectfully submit that there was more than sufficient in the materials before the Divisional Court to make that absolutely and entirely clear. Just to pick up a couple of them, if you go to the core bundle, the core permission bundle, if you would, and you go to page 630, 30. This is the ministerial statement to Parliament, making it clear that the government was treating this as one of those exceptional cases where the normal rules wouldn't apply.
Are we entitled to look at the ministerial statement to Parliament as opposed to decision letters?
My lord, you are for this purpose. No one's quibbled with the admissibility of this
I
on.
appreciate no one quibbles with it, but that doesn't always mean it's right, because there have been sort of various issues about setting aside written ministerial statements that have been raised.
My lord, yes, but I'm not sure they will work in this context, not least because on the face of the SELC, as you remember, one of the conditions, if you are going to disapply this, is you've got to go to Parliament and take the heat. You've got to take the accountability. So my submission is that legally it's entirely relevant and it doesn't breach any of the Article 9 or parliamentary privilege issues that might otherwise arise with statements to Parliament.
Thank you.
So it hasn't been challenged, and my submission is that it couldn't successfully be challenged.
So where are you taking us to on page 6?
My lady, I was just looking for the relevant bit. Hang on, let me just find the relevant bit. They consider F-35s over the page on page 630. And they explain why it is that they're taking that out. And you'll see that they say in the pre-penultimate paragraph, second sentence, where they say, starting that paragraph, in this context with a view to ensuring. Can I invite you to read that paragraph in particular? So the Secretary of State has gone back to Parliament consistently with the terms of the SELC themselves and told them that he was taking a decision outside the framework and rubric of this. You get a similar sort of statement in virtually identical language in a written answer to questions, but we don't need to trouble you with that.
And this was the 2nd of December as well?
This
September.
was, yeah, this is 2nd of December. Thank you.
September.
September, sorry.
September, yeah. I just wanted to pick up on one point that my learned friend alighted on, or two things that my learned friend alighted on. If you go into the supplementary bundle, they seem to be in support of some form of thesis that what was being disapplied in relation to F-35 was simply criterion 2C and not SELC. And I think he relied first of all in tab 4 on a 24th of July ministerial submission to the Foreign Secretary. It's in the supplementary bundle, tab 4, page, I think it's 75, it's little numbers on the right, bottom right hand corner. So supplementary bundle, the one with 12 tabs in it. So many different ones, sorry. Yes, that looks like it might be 12 tabs.
Okay.
You want tab 4 of that. Page 75 if you go on the bottom right hand corner numbering.
Thank you.
And you'll see that all that one does is to consider the F-35 Joint Strike Fighter Programme, and then in paragraph 10, paragraph 9, they're referring to all the relevant criterion that might apply to the broader question about export of arms. And then they move to the F-35 fighter programme, and the recommendations you see from paragraph 10 is that licenses for the F-35 programme are excluded from any suspensions. So that doesn't perhaps take one a great deal further. The point that the ministerial submission that was principally relied upon below and referred to by the divisional court in their judgment was the 30th of August one, which is behind tab 6 and starts on page 80. And my learned friend says, well, look at paragraph 13, that's the critical bit. Again, I don't respectfully submit that takes matters any further at all, because you'll see from the structure of this submission that what is being dealt with there in paragraph 13, as in the section that begins above paragraph 6 with extant and new licenses for Israel, what is being dealt with there is the shall we suspend at all question. So that's the context in which paragraph 13 sits. And then after that has been dealt with and the relevant ministerial authority has been sought, you get to the important bits for present purposes, and they are the bits that the judgment of the divisional court cites at paragraph 38 of the judgment of the divisional court, citing I think it's paragraph 25, but you'll see the section in which that sits. They describe the context of the decision above paragraph 16, background to F-35 programme and licenses, and then they get to the advice bit above paragraph 24 in the title, and now we're dealing with the F-35 programme. And you will see that when they're dealing with the F-35 programme, they effectively adopt or invite the Secretary of State to adopt the line that we've already seen the Secretary of State did in fact ultimately adopt, which is to, as they put it, depart from the SELC. First sentence of paragraph 25, which was the one the divisional court quoted, paragraph 38, for the F-35, and exclude them from the scope of the suspension. This would be in line with the written ministerial statement that issued the SELC in 2021, saying that they would be without prejudice to the application to specific cases and so on. And then my Lord Justice Dingemans rightly drew attention to 26 and 27. Again, all of that is inconsistent with the revised and narrower thesis, if that's what this part of the appeal is founded upon, that this was all to do with simply disapplying criterion 2C and not disapplying, in effect, SELC pursuant to the permission which the SELC policy or guidance had already given. So we respectfully submit that there is no proper basis at all in the materials, even in the base materials, before you get to the height of the hurdle that has to be overcome to challenge a finding of fact by the court below. There is no basis in the materials at all for the idea that in relation to the F-35 fighter programme, the Secretary of State was in some way invited only to disapply criterion 2C rather than disapplying SELC in its entirety. I'm not going to take up time quibbling with my learned friend about pleading points, but I think at one point he made a submission that our skeleton below did not run any sort of argument that the SELC had been disapplied. That, I'm afraid, is absolutely and flatly wrong. See paragraph 39.1 of our skeleton, which refers back to paragraphs 1 to 10 of the skeleton, but the relevant ones for present purposes are paragraphs 6 to 7 on the reference back. But the key paragraph making it entirely clear that exactly this point was taken in the skeleton. See core bundle, tab 9, page 306. And the important part about this is, and the reason I start with this factual point, is because it provides a complete answer. And I go back to the discussion I was having with my Lady Justice Whipple. It provides a complete answer to this ground because the case that was made below and the case that is persisted in is in effect that the SELC is the policy, so it's a bit like EOC and ECAT. You can argue uphill and down there about whether ECAT was a special circumstance and a particular set of features that don't apply here and all the rest of it. But the long and the short of it is to even get those arguments off the ground, you have to be in territory where you've got a formal policy of that kind. And certainly in the context of ECAT and policies designed to give effect to that, the current state of the case law, however confusing it might be as to how far it extends, and whether right or wrong in relation to some of the concessions that might have been made by some people in this court earlier on in some of the cases, may need to be revisited at some future point. It doesn't terribly matter, because you can only get into that game if you are dealing with a policy, and you're not in that game. They don't suggest you're in that game unless the SELC applies, or the part of the SELC that they want, which is criterion 1, applies. And they can't get there because this is a complete factual shutout for that argument. And the significance of that is that that argument, based on policy, is the only argument that is mounted for saying that correctness is the standard. You'll remember Mr. Hussain saying to you, there's no case, ED cites no case, where policy has been treated as subject to the tenability standard. But that's the foundation for that narrow argument as well, given that they can't challenge tenability as a finding. So this is a complete answer, we respectfully submit, to the appeal that is being made on this ground. In any event, that's point 1. In any event, there was, we submit, no domestic foothold anyway sufficient to displace the well-established starting point. And that is the subject of the alternative reasoning, or the various other independent reasons that the court gives at paragraphs 110 to 112. 110 to 112 of the judgment. The core point being made by the divisional court at 112 is that insofar as there is any domestic foothold via the SELC, which had in any event been displaced, given the nature of the decision that has here been made, that will be insufficient as a matter of law to constitute an exception to the principles that I've already addressed. And we respectfully submit that that was an entirely appropriate conclusion that the divisional court were entitled to make. I don't need to go here, but I do go here if necessary.
Can I just ask you one point? Suppose you're right on your sort of paragraph 130. What is the position if we thought that paragraph 112 might be wrong, but would make no difference on an appeal? I mean, would that be a compelling reason to grant permission to appeal?
My lord, no, because you couldn't have a compelling reason, would be my submission, which didn't lead ultimately to a different result. It would have to be addressed in a future case if someone wanted to take that one forward as a separate and discrete point of principle. The court doesn't exist to resolve academic disputes, would be my short submission in relation to that possibility.
Thank you.
Can I address the substance of the point? And I suspect it's the substance of what lies behind my lord's question anyway, which is the argument that says, it's in effect the Miss Kaufman's argument that says what the court has done is to mistreat or to invent a principle which is based on restraint and respect in the context of foreign relations, national security and so on, and has treated that as a ground for concluding non-justiciability. And our short answer to that is that that is plainly not what the court was doing. They do not invent, in relation to the conduct of foreign relations, international peace, national security and all of that, they do not invent some separate and freestanding basis for non-justiciability. Instead, what they do is to recognise that those categories of subject matter are categories which the courts have traditionally been extremely slow before intervening to overturn government decision-making about. And they've been extremely slow to overturn those sorts of decisions for very good and obvious constitutional reasons, which we all know and love, and which have been explored endlessly, as it were, in the Supreme Court recently, culminating in, for example, the U3 case. But they are to do with democratic accountability and constitutional expertise. But it isn't a base principle that is necessarily exclusive And I emphasise necessarily because there are certain contexts, and it's important to recognise this, there are certain contexts in which that discrete principle, based on the sensitivity of the subject matter, in which the court will not review a decision. You can call that non-justiciable if you like. You can call it not exercising a discretion to go there if you will. It matters not. The court will stay its hand, whether on a discretionary or a jurisdictional basis doesn't matter.
It does matter a bit, doesn't it?
Well, it can do, but I say doesn't matter because that was the way in which it was ultimately left, however unsatisfactory in CND, if you recall. They said, well, there may be an interesting jurisprudential dispute as to whether or not this is a matter of jurisdictional discretion. Doesn't matter, we won't go there. But my point is that there are certain circumstances when you're at the extreme ends of that territory where the court will simply not intervene. They will not overturn decisions because it is sensitive territory which it is for the government to decide. One has that, for example, if you think back to cases like Abbasi. Abbasi, I think it was 106, referred to as long as you don't go to the forbidden territory, there isn't an objection to us looking to see whether the government created a legitimate expectation they would intervene for people in Guantanamo Bay if they were British citizens. But that isn't to say you can go further and start second guessing and telling the Foreign Office to go off and do it or to do it in this way. So there are circumstances
Is
of
that
the,
a sort of constitutional competence point?
it's two things.
Yeah.
And the foundations for it are the foundations that were explored both in relation to public law and, as importantly, in relation to convention challenges. And they are invariably democratic accountability. Lord Hoffman's postscript in Raymond, look at the cost if they get it wrong, see the Twin Towers. And expertise and experience residing centrally within government, sometimes called, perhaps offensively, institutional competence. I wouldn't be so bold, but you have the idea. It's those two things that base it. But my point is that whilst of course it is true that there are no, the bastions one by one have fallen, there are still some areas or some aspects where the court will stay its hand on whatever basis in these areas. The fundamental point here is that the court below, unsurprisingly given its composition, was very well alive to that basic idea and those extremities. And the core point to bear in mind when rereading the judgment with this set of issues in your head is that what the court was doing here was not to say we're treating foreign relations or international peace and security as a no-go area just to shut out the court's jurisdiction. We know they weren't doing that because they looked at rationality challenges. They can't have been doing that. What they were actually doing was to look at the situation as to when you can and can't and shouldn't look at unincorporated international law. And they recognised that sometimes in the case law they said no jurisdiction, and sometimes in the case law they said it's a tenable standard, IOC satellite, Friends of the Earth, Paris Agreement and all of that. And they were trying to work out or work through where on that spectrum, say for heritage, where on that spectrum they lay. And for that purpose, this was decision making in that sort of context was important. And it was important because it provided an additional supporting set of reasons for the court not going there. I referred you to Abbasi as a sort of case where they recognised that you could have a situation in which this was forbidden territory. Al-Haq 1 is another example. It might be treated as an extreme case because Mr. Fordham was suggesting that he would quite like to dictate what the Foreign Office policy ought to be in relation to Gaza all those years ago. And the court weren't having any of that. But the fact of the matter is that they did conclude that they were not going to deal with that challenge, that type of challenge, on non-justiciability grounds because of the context. As I say, they didn't need to go.
I suppose you could say that it's not really a foothold point at all. It's a different sort of no-go area point, very well covered in the case law. There are certain sensitive areas where the courts just fear to tread.
Yeah.
And perhaps it could be said that having hung it all on this foothold point, it's an uncomfortable alliance of concepts. uncomfortable juxtaposition.
My lady, I'm not sure I would even accept that discomfort, if I may respectfully say so. And I don't accept the discomfort because the court was ultimately grappling, and you can call it domestic foothold if you will, but it was ultimately No, well, they did.
Do my best.
They did in part, but what they ultimately did in terms of the structure of the judgment was to set out the related bunch of principles and strands of principle and then analyse them all together. And then when they came to the conclusion and to the reasoning, the 110 and following, what they were doing was still to be considering the question, should we accept the claimant's invitation to rule on the interpretation or application of things relating to genocide, all that unincorporated international law that they were trying to rely upon. And they concluded that they shouldn't do that, one, because it was non-justiciable in the strictest sense, because it was unincorporated international law, see Lord Reed and everyone else, but two, also, if there was then a question as to whether they should go to tenability even, that was a question of fact and weighing up all the circumstances. That was from Save Heritage, some circumstances where the courts have gone to tenability. So they were considering it in that context and for that purpose. And for that purpose, it must be relevant, and they treated it as relevant, that you were dealing with decision making of this kind where the courts have been, at the very least, wary to tread. That's how we conceive the judgment with respect to them. And I did want to remind you, for this purpose, of paragraph Yes, I referred you to Al-Haq as one of the examples of the cases where they'd done it in this way and refused to go there. That's paragraph 82 of the judgment. But the more significant paragraphs I wanted was the paragraphs that expressly make it clear that they were well alive to the potential distinction between non-justiciability and deference, as they put it. Look at 88.
Yeah.
You have those paragraphs. Look at the title. And if you read 88 to 90, you will see the basic conception that I hope I've accurately described as to what they thought they were doing in relation to all of this. Just to come back to my learned friend Miss Kaufman's submissions this morning, I suspect not remotely like the submissions that were made to the divisional court, but it doesn't matter. If there is an attempt to say that all of this is basically foreign act of state, we strongly and respectfully disagree. These are separate strands of principle with their own separate constitutional underpinnings. We know the constitutional underpinning for straight non-justiciability on J.H. Rayner grounds. Executive can't make law, it's unincorporated, Parliament needs to pitch in if it's going to draw something from the international plane because we're dualist. We know the basis for foreign relations, international peace and security judgments of that kind. Careful, careful, careful. Sometimes stay or hang completely. Sometimes rely on it as a relevant factor to dissuade you from doing something else. And those are separate principles. Foreign act of state is another principle, albeit that to some extent it arises in similar contexts, but as I'll come to in due course, that is a principle which is, in relevant part, fundamentally dependent upon the base idea that it is not for domestic courts to start opining on wrongdoing by foreign sovereign states, unless to do so is essential for the purpose of determining a right or obligation that exists under domestic law. So they are different principles, albeit that there are degrees of shading between them, and they have different jurisprudential foundations. And the divisional court, we respectfully submit, was well alive to that. That's why the judgment is set out describing the various strands of principle and then dragging them together, indicating in 88 to 90 that they well understood that these were different things, and justiciability and deference were different ideas in different contexts. And one can see, in answer to a question my Lord Justice Dingemans asked of my learned friend Miss Kaufman, in paragraph 89, Justice Simon Brown's summary of the conclusions in the CND case, I think the question was, is that, or do you, Miss Kaufman, say that that is foreign act of state? We respectfully submit that it isn't, and nothing in Lord Newburger's judgment suggests that it is. 47.1 is J.H. Rayner, pure and simple. And 47.2 is effectively restraint, constraint, deference, or Abassi, or Abassi, or Al-Haq 1. But those are the ideas that are flowing there. I think I'm right in saying that nowhere in CND is there any reference to foreign act of state, whatever. But those are the principles that they're relying upon, and those are the principles that correctly the court identifies to describe the two things that it's dealing with in those paragraphs of the judgment. That's all I wanted to say about that. Tenability I've pretty much covered. This was a third alternative and independent reason why ground 8 must fail. See paragraph 116 of the Divisional Court's judgment. Which is that if there was some way in which the unincorporated international law could be regarded as being justiciable in domestic public law, the right test was tenability, and it was plainly a tenable approach that had been adopted by the Secretary of State in deciding that the actions were taken consistently with that unincorporated international law. And I've been through the procedural bits and pieces in relation to that. There's no challenge to that finding, so one proceeds on the basis that the view that was being challenged, that this was consistent with international law. And you'll recall it wasn't just a sulk, there was a self-direction, as there very often is in ministerial submissions. I can't remember which court it was, but at least one of the courts, it might even have been in Cornhouse, pointed out that the domestic courts or the politicians will very often have to direct themselves by reference to unincorporated international law. That's a jolly good thing rather than a bad thing. But the point on tenability is no challenge to that finding. So my learned friends have to go further and to demonstrate that tenability was not even the right standard. The only basis on which they seek to do that is that SELC applies, but there's a complete factual answer to that because SELC was specifically and expressly disapplied. But if you get into that tenability case law, and to some extent they're parallel tracks and parallel lines of case law, but if you get into that case law, you will see that very many of the underlying features that support tenability as an approach are self-evidently and obviously present here, including in particular the difficulties of a domestic court ruling on deeply controversial issues of international law, where there is no clear and well-established guidance. The only two cases in which they've ever really done it on a self-direction are Launder and Cleverly, which, as you saw from the Divisional Court's judgment, were explained, we submit entirely correctly, on the basis that they were wholly exceptional facts. And they raised ECHR issues on which there was very well-developed jurisprudence in the days before the Human Rights Act had come into effect, but very shortly beforehand. By contrast, you have here deeply controversial aspects of unincorporated international law going to massively important state interests with massively important reputational consequences and ultimately no clear guidance. Go back to the tenability finding, which isn't challenged. So we respectfully submit that tenability plainly is the right approach, applying those basic principles if you get to that place. James. But you don't need to. 2 minutes. No, that's true. My lady, would you mind rising for 2 minutes while my learned friend Mr. Hussain?
Yes, of course.
Court rise of able.
5 minutes.
Sorry, James.
Thanks. I don't actually know. A bunch of new employees came in yesterday, and none of them can do that IT test. Oh, this is so bad. She was quite
Normally that is
You what are we doing? I'm in two screens. Can I also say
Yeah.
I have so many wires. This is user place, and they are absolutely fantastic. I like that.
it's a separate computer because I've got envy of stuff. I've got envy of that. It's quite good. Is it an actual computer?
Court rise if able.
I'm going to ground 2, if I may, which is reception of customary international law into the common law. And the case that we make in relation to that aspect of is that customary international law, to the extent that it's unincorporated, is to be treated as other species of unincorporated international law subject to the case law. It isn't automatically part of domestic law. The principle is that it should be viewed as a source, and as that implies, it is a source of law that the court may draw on if considering developing the common law, and as such, it is subject to possible domestic, legal, including in particular constitutional objections to its reception, even as customary international law. Would it, for example, conflict with legislation or trespass into territory that Parliament has considered and legislated for? Is it a subject matter which one would expect Parliament to legislate for if it wanted to make it domestic law, because it contains nuances and complications and balances that are essentially legislative? It's also subject, we submit, to the base constitutional doctrines that we've been discussing, namely dualism and care in relation to foreign relations and matters to do with defence and security and so on. The test here is that set out in law debenture, and you have perhaps the key bits from law debenture in the judgment below at paragraph 128. Let's remind yourselves of that. Just to pick up on a point about whether or not the divisional court correctly identified the test for incorporation, we respectfully submit that that's a hopeless argument. The idea that they misunderstood the test for incorporation. You see from paragraphs 125 onwards to 128 that the court set out accurately, we submit, the key principles from the authorities. They include at 125 the quote from Freedom and Justice Party, including not merely the idea that customary international law is a source of common law rules, a point that one also gets from the Supreme Court's judgment in 204 of law debenture cited at 128 of the Divisional Court judgment, but also includes the passage about the general proposition which includes the presumption. If you look in paragraph 125 of the Divisional Court judgment in the citation from Freedom and Justice Party, bottom of page 102, paragraph 115 of the judgment in Freedom and Justice Party, do you have that, the Lord Mance reference? And you'll see that the Lord Mance from KU passage that is quoted contains that bit about the presumption. Al-Haq then asserts that the Divisional Court failed to deal or didn't understand correctly the distinction between muddle, I think is the way it was put this morning, but didn't deal sufficiently clearly with the distinction between whether something is customary international law, to which the Benkar-Bush test applies, strict standard high hurdle before you can show that something is customary international law, on the one hand, and secondly, the test for reception. But it's perfectly obvious, i.e. reception, if it is properly characterised as CIL. But you can see perfectly clearly that there was no confusion on the Divisional Court's side about that. Look at paragraph 130 of the judgment. Those are the two things that are said to have been muddled up. far from muddling them up. They're treating them as separate and discrete issues and identifying them as such. And that is why, when you get to the title above paragraph 131, they're dealing with the Benkebush test. Is it a rule of CIL? So when my learned friend, Mr. Steyn, I think it was, says that 131 is muddling, 131 isn't muddling at all. It's applying that test to the question, the first of the questions identified at 130, which is whether or not something is in fact CIL. And you get to the separate question, which is whether or not if it is CIL, it ought to be admitted. And that's dealt with under the title Constitutional Principle at 134. So there was no misconception about the nature of the test that would apply and should apply and how this would all work. And I wanted to pick up 2 or 3 points, 3 or 4 points perhaps, on the second of those issues, in other words, reception, and whether or not these parts of unincorporated international law, assuming that they are CIL, even assuming that they are CIL, there's a pretty big issue about that.
Can I just ask how you read 133? So they say they assume it's CIL, but appear to say but it's not widespread, representative and consistent practice, and therefore doesn't satisfy Benkebush. Is that what they're saying there?
I think it probably is. I mean, I'm very well aware that they were prepared to assume without deciding, first sentence of 131, that the obligations in question are part of customary international law, so as it were, they go on, and then they seem to express doubts about whether it would actually satisfy that test in the first place. So it's almost an even assuming that they do.
They seem to be making a distinction between the sort of high-level principle and content.
Yes, genocide versus genocide, a bad thing, precise content of a state's obligation.
What does that actually mean for an individual state? That seems to be where they were.
I think that's the way they looked at it. But my lord is right. There's still a question about why would they go to stage 2 if they've already decided stage 1 against, as they appear to have done. But my lady is also right. I mean, we've had that distinction has existed in myriad different contexts over the years, and I have in mind a case I think was called Mohammed and the Secretary of State for Defence, which my lady might have been involved in this anyway, but it was a decision of the Court of Appeal, Lord Justice Lloyd Jones, who then was giving the judgment, and perhaps Mr. Justice Leggett at first instance. It was one of those Iraqi-Syrian type cases, and the issue there was whether or not there needed to be a public inquiry into allegations of torture by British forces. And one of the arguments that was run was that this was CIL, therefore it was already part of domestic law. And the judgment that I think Mr. Justice Leggett certainly reached, I think upheld by the Court of Appeal, was, of course, torture is CIL, your Skogens and every other Latin title you can think of. That's about as important as you can imagine. It doesn't necessarily follow, however, that all the incidents, even if they're incidents that are expressly named and set out and dealt with more or less opaque or aspirational terms in UNCAT, are themselves part of CIL, and they included for relevant purposes the nature of an investigation that might need to follow from an allegation of torture. So it's exactly that distinction that we respectfully submit does exist, and I'm sure my lady had in mind. But however that may be, and precisely whatever the outcome is of 131, 132 and 133, they then go on to consider should it be received anyway, and it was on that I wanted to make a couple of submissions. The first submission, assuming it's CIL, is that there is an initial but relatively serious concern about cutting across the basic principle that unincorporated international law is not the source of rights and obligations. That in itself is the foundation of the core constitutional dualist principle. CIL may of course have a broader state consensus and reach, but it is subject to essentially the same domestic constitutional considerations as other unincorporated international law, like treaties. Parliament makes the laws, not the executive. It's one thing to develop a common law principle with all of the incremental and cautious approach that involves, quite another to import wholesale this sort of body of rules. And that leads to the second point. It isn't, we submit, apt, flowing on from that, for the judges and the courts to make that sort of jump. This isn't in any sense, or wouldn't in any sense be, as it were, incremental development of the common law. This would be the wholesale importation of controversial and critical standards that exist on the international plane, and it would be a radical step to introduce that unincorporated international law with all its uncertainties and all the rest of it. I mean, there would be serious considerations and questions about how any such wholesale importation could actually work anyway. Do you take in some of CIL, or do you take in all of it, or how do you make that distinction? Do you drag in the whole of IHL so that all the principles of IHL that govern military operations abroad, for example, on the international plane, suddenly become domestically enforceable legal standards? I might have thought it would be a matter for Parliament to make those sorts of choices and not the courts. If you're going to have some but not all, if you're going to need to think hard about what form the transposition ought to take if you're going to bring them in, those are legislative judgments. They aren't judgments that the courts could or should properly be making. So those are the first 2 points. The third point is that the reluctance of the courts to get involved in second guessing, even if it's at the less extreme end where it isn't forbidden territory, as it were, the Abbas is forbidden territory, but there's still deep reluctance and caution needed before intervening in areas of foreign relations, defence, international security, and so on. That itself is a thoroughly important constitutional principle which need to be thought about if customary international law was being held up as something which the common law should simply receive in a way that might well cut across and impose wholly new standards, and indeed take away options from government in that sphere, because that's the effect of it. That would be the effect of it. And it was that point that the Divisional Court were obviously particularly concerned about at 134 in the judgment. Fourth and final point has two parts. The first part, or the submission, is that this is, or this would be, an inappropriate context in which that sort of reception could take place, because Parliament has already made choices in the field. Perhaps three different aspects of that. The first of them, A, is that it's clear that Parliament has not decided in the context of export control or at all. You can see how these standards might well be interesting in other contexts as well. Parliament has not decided to incorporate the sort of sways of CIL that my learned friends advocate. Relatedly, B, by contrast, Parliament has enacted legislation specifically to give effect to some international law rules on IHL, international humanitarian law, rules of war, genocide and war crimes. You have the Geneva Conventions Act 1957, which does not incorporate Common Article 1. But the International Criminal Court Act 2001, which criminalises genocide but does not incorporate the obligation to prevent genocide. Back to the point we were discussing with my Lady Justice Whipple a minute ago. And Al-Haq's argument on incorporation of the CIA rules they want for their purpose would directly cut across those legislative choices. Thirdly, C, the legislative scheme here, in other words, the Export Control Act, positively and very significantly undermines Al-Haq's case. If he is right that the customary international law rules in question are part of domestic law rules as controls that public law imposes, in other words, domestically enforceable rules that government has to abide by, that cannot be squared with the nature and structure of the Export Control Act. And the reason it can't be squared with that is because that act envisages and sets out a very much lighter species or form of control on the government. You have the relevant provisions of the legislation in the court's judgment below at paragraph 14 through to the end of paragraph 18, setting out the key bits, but the critical parts, as you will no doubt already have noticed, are firstly, well, the first point to note about the Act is that it doesn't incorporate from an Article 1 the Genocide Convention, the Arms Treaty, or any of the other rules relied on. They are and they remain unincorporated international law. Section 5 simply sets a limit on the power to impose export controls to the authority in that section. But the section is very broad, as you see from the terms of it recited in paragraph 14 of the judgment. And section 9, and in particular 9(4)(b), when read with paragraph 3 of the schedule, which is quoted over the page, the relevant paragraph being B in that schedule as well, that simply requires guidance about general principles to be followed when exercising licensing powers. It is not imposing standards from international law. It's simply saying you need to give to Parliament guidance about how you're proposing to exercise that power in relation to issues relating to any possible consequences of the activity that are of the kind in paragraph 3 of the table. So the guidance is mandatory and must cover this, but it's entirely non-prescriptive about even whether any consideration needs to be given to those matters. In no sense can it be said that section 9(4) renders international law applicable or even of central concern. And if anything, it suggests the opposite. It makes clear that it would be open to the Secretary of State to issue guidance which states in terms that no consideration, as unlikely this may be, that no consideration is to be given to whether the exercise of powers breaches international law. Any form of guidance of that kind would be entirely consistent with 5(4) and entirely consistent with 9(4), and indeed entirely consistent with the principle of dualism. So we respectfully submit that this very Act is inconsistent with the idea that all of these international standards, specifically referred to in the Act itself for the purpose of the guidance, to treat those as being domestically enforceable standards anyway would simply undercut that regime. So that's what we say about that. Ground 5 and foreign act of state, if I may. I've already made the point that this is a distinct set of principles. It is not right to collapse all the principles we've already been discussing and I've been addressing you on as being within foreign act of state without more, as it were. It's a distinct set of principles to do with particular concerns, in our case particularly about the worries of the court being dragged into ruling on the legality or otherwise of the actions of a friendly foreign state and being seen to do so. And I deliberately split those two concepts out because the being seen to do so, as we'll see from the Al-Haq case approved by Lord Sumption in his judgment in Belmarsh, is an important part of this. But I wanted to make three short points in relation to foreign act of state in response to the way in which the arguments are being put. Firstly, the appellant now contends that the lawfulness under international law of Israel's conduct was, as it's put at paragraph 55 of its skeleton, not at the heart of the appellant's challenge. That, with great respect, is an unreal submission. And the Divisional Court evidently regarded it as an unreal submission, particularly for anyone who sat through the Divisional Court hearing, including the peroration that was given by Mr. Hussain in opening that application. But we have set out in our skeleton below the collation of references to the illegality or unlawfulness of Israel's conduct. See for that purpose our skeleton below, paras 42 to 46, call bundle tab 9, page 308 and following. And Al-Haq has repeatedly pleaded to the unlawfulness of Israel's acts. See, for example, and I just give you these by way of example, the amended statement of facts and grounds, if you have that, core bundle tab 11, if you can just take that up. Core bundle tab 11, page 517. Paragraph 224.
What is this?
This is the amended statement of facts and grounds.
Thank you.
Starts on page 424. And this paragraph 224, sits under the title that you see above paragraph 221, which is incompatibility with the UK's international legal obligations to prevent genocide under Article 1 of the Genocide Convention and Custom International Law. Go to 224 and 4 lines down into 224 on page 517. It is Al-Haq's position that Israel is committing genocide in Gaza. And just whilst you're there, if we may, in relation to the submission that tried to draw a distinction between acting consistently and breaching international obligations, and the distinctions of that fineness that were sought to be drawn again this morning, if you just go back to 201, it not being said that the UK was in breach, 201 on page 508, right at the beginning of ground 8, you'll see it says SSBT misdirected himself, erred in drawing determining the carve-out is consistent with the UK's international obligations. The export of F-35 parts to Israel breaches the following international law obligations of the UK. So the UK is being said to have breached, and there isn't therefore that sort of distinction between consistency and breach. But go back to Israel's position, if you go forward in the reply, in the supplementary bundle, sorry, just keep the core bundle with you if you will for a moment, because I'm going to come back to the skeleton, but if you have, and take up the separate supplemental bundle, and you go to the reply, which is at tab 3, starting on page 21 of that. And you'll see at the very end of subparagraph B on page 56 of the bundle, 36 of the internal document, but 56 of the bundle, subparagraph B within paragraph 59, and you'll see the final sentence of that, the UK's contribution to Israel's violations of IHL through F-35 bombardment plainly meets the threshold of substantial involvement. I said if you would keep, please open the core bundle. If you go back there to the skeleton argument below paragraph 14, that's behind tab 8 of the core bundle. Paragraph I want for present purposes is paragraph 14 to start off with.
Sorry, can you give me that?
Yes, it's tab 8 of the core bundle, page 128, paragraph 14. Israel's assault on Gaza is a moral stain on the conscience of our collective humanity. Just over 18 months, Israel has decimated an entire society. The Israeli army has committed genocide, war crimes, crimes against humanity, against the population in Gaza, deliberately targeted women and children, etc. Committed acts of torture and rape. You see the thrust of it, paragraph 14. And it goes on, including in paragraph 16. What is happening in Gaza, so 16 is a live stream genocide. And that wasn't just, as it were, incidental reference. You'll have seen the references to the oral argument below, and you'll have seen in particular footnote 11 to paragraph 62 of the Divisional Court's judgment. Reciting those passages from paragraphs 14 and 16, and then pointing out that there was a debate at the beginning of all of this hearing in which Mr. Steyn was positively insisting that the evidence supporting that allegation was an important part of the claimant's case which it should be allowed to deploy. So that is the position, however much my learned friends would like now to minimise all of this. Second point on foreign act of state is that there is no real engagement with the core findings at paragraph 122 of the judgment. This is under the title Foreign Act of State, which starts before paragraph 119, and you've seen the references there, but 122, there's no real engagement with that, and in particular the conclusion of the court that, as in Nur Khan, which was the case about a drone strike, which was said to be, in which it was said that the intelligence provided from the United Kingdom to the United States made the people who provided accessories to murder. That was an attempt to get a declaration out of the domestic courts to that effect. They say in 122, as in Nur Khan, the decision by this court, the F-35 carve-out was contrary to the international obligations of the UK, would necessarily entail a condemnation of Israel's conduct and would be understood in this way internationally. And there's no addressing of that. And it is perhaps important just to see the paragraphs in Nur Khan that are referred to. If you go to, you should, I hope, have whether it's a black or a white file. It was a file of additional materials that we handed up this morning. If not, I can probably take it from Belhaj. But you've got Nur Khan in there, behind tab 3, a judgment of Lord Dyson and Lord Justices Lord and Elias. And the paragraphs I wanted, for present purposes, which are the ones effectively referred to by the Divisional Court in the paragraph we just looked at, are 36 and 37.
Sorry, which tab am I looking at?
You're looking at tab 3 in that one.
Paragraph number again?
Paragraph 36 and 37. You probably better start at 35 to see the nature of the point. What was being said was, you don't need to rule on any of the American stuff, because all that matters is whether the English people were acting as accessory to murder. And what effectively 36 and 37 do say, yeah, well, that's all very well, but that's not the way it's going to be seen. And the way it's going to be seen is an important base for the principle, in relevant part for the principle. You see, in effect, the conclusion of the court is expressed in paragraph 37, focusing on how it will be understood and on the reality of matters if the English court do start making findings, even if they're only restricted, in effect, to the liability of UK individuals. Does that make sense? So that's it's an appearance thing which is very important and serves to engage the principle. And you get Lord Sumption revisiting that in the Belhaj case, which is in the main authorities, and put that away now, you go back to Belhaj and Straw, and you go behind tab 17 of the authorities bundle. I want paragraphs 2, I'll give the page number in 1 second, 2, 2, 3, in the speech, and then the judgment of Lord Sumption, page 783.
Thank you.
So 783 of Belhaj, behind tab 17, page 783, I want paragraph 223. And you'll see that you don't need to go to the first of those paragraphs. The analysis of Khan starts at 223, but the key bit that is relied upon is in 224, and you'll see that the citation with approval in effect, if some explanation in what follows under the quotation, is from 36 and 37 of Khan, making the point I've made about the importance of how things would actually be viewed on international claim.
Was Lord Sumption part of the majority in this respect?
Well, that's in the context of Belharsh and Straw,
Question.
in the context of Belharsh and Straw, that's an extraordinarily difficult question to answer.
You need a spreadsheet of the
Yeah,
judgment.
I mean, it's one of those cases where this isn't critical to the reasoning or to the ratio, but this is at least of some interest as an analysis that adopts that. I mean, if necessary, we rely simply on the finding of the unanimous Court of Appeal, which he cites with approval in effect. And the Court of Appeal judgment plainly is binding and unanimous. And that leads to the third point, perhaps, which is the reliance by Al-Haq on the law debenture trust case. Again, I can just take this quickly and give you the references rather than inviting you to turn them all up. Their skeleton for this purpose, for our hearing today, so the appeal skeleton from the appellant to paragraph 54, relies on law debenture trust at 188, quoting from Lord Sumption in Belharsh. Foreign Act of State will only apply where the unlawfulness of the Foreign States Acts is part of the very subject matter of the action, in the sense that the issue cannot be resolved without determining it. The difficulty with that from the appellant's point of view is that you see how Lord Sumption himself reasoned the Al-Haq, the Noor Khan decision, suggesting that appearances were very important. But one also might note, you might choose to note when you feel the need to go back to law debenture, how the thing worked in law debenture trust itself at paragraph 190 to make out in that case the pleaded claim of duress. All that needed to be established was the fact of what Russia had been doing, i.e. the threatened use of force, not that it was unlawful. That's very different from the claim in this case, where the allegations of unlawfulness of the friendly sovereign state are all over the pleadings and are pretty much an essential part of the way in which the basis for unlawfulness is put. The UK is on no view here the primary actor, and all of the unincorporated international law breaches that are asserted are squarely anchored that in a variety of different ways, pejoratively described across the pleadings and the skeleton argument, Israel has acted in gross violation of international law. And that isn't a question of pure fact as to whether or not they've acted in that way. Even if it was, you fall squarely within the Noor Khan principle. That isn't how it will be perceived on the international plane. So that's what we say in relation to foreign act of state by way of response. Can I then turn briefly and finally to ground 3 and the response to the 5230?
Can I just check before you leave that? Para
Yeah.
119 of the judgment.
Yes, Mum.
So foreign act of state is relevant only to ground 8, is that right? The conclusion of the divisional court which is attacked by this ground.
Yes, it's a different ground, I think, isn't it?
Yeah,
It's part of ground 8, but it's now ground 5 of the appeal.
right.
So there's another reason why you were saying it was non-position.
It was, as it were, an alternative argument beyond the arguments we've already covered. Another reason for saying the court should not intervene to do the thing that they were being invited to do, because it was
I'm just trying to work out how this fits with what you say is a factual answer to the findings. I mean, would it matter?
Yes, I mean, if we are right on that factual answer being a complete answer, then you don't get anywhere near foreign active state because it's just an alternative route to the same end.
I'll have to check, but that was my
Yes.
subjective understanding.
Yes,
I mean,
well, my
obviously
lord,
it
I think-
doesn't help with the grounds changing, which for obvious reasons, why the number of the grounds changed between
No.
first instance and here.
No, I think that's the way it does work. It's an alternative way of reaching the same endpoint, which is you shouldn't go here.
Thank you. Sorry to interrupt.
Not at all.
So the reopening application.
The reopening application. Ground 3 raised 2 errors in what was said to be ground 12 below. That the divisional court erred, it was said, in concluding that the Secretary of State for Business and Trade had adopted a rational process when deciding whether to depart from his policy. That's the rationality ground, and that the divisional court's decision was unjust insofar as it was based on matters which Al-Haq had been precluded from challenging by the earlier decision of Mr. Justice Chamberlain. That's the procedural injustice ground. Lady Justice Andrews refused permission to appeal on the basis that ground 3 was unarguable. See Call 100, tab 20, page 636. And she held that that was so in relation to the rationality ground. See paragraphs 11 to 13 of her reasons. In summary, because the divisional court, in her view, had plainly been right in applying the legal test that they did. So correct legal test and an appropriate standard of review, high standard if it's procedural irrationality or aiming at. She rejected the idea that the divisional court's reasoning in this respect was circular and or didn't support the conclusion it reached. She noted that the Secretary of State did not contend that the risks of suspension could never be outweighed by countervailing risks, but there may be cases in which it was obvious from the information or evidence available that the scales fell on one side or the other without the need to carry out any more detailed calibration. And this case fell into that category, essentially because of the strength of the concerns about the effects and impacts on international peace and security that I opened with. And in those circumstances, she concluded the absence of an attempt to calibrate in agreement, in effect, with the divisional court was not irrational. In relation to the procedural injustice ground, she held at paragraph 10 that there was no substance to the complaint of procedural unfairness, and that the divisional court had been entitled to describe the process adopted by the Secretary of State as careful and thorough. That, after all, appeared on the face of the documentation. And given that there had been no finding that the methodology was unlawful and no extant challenge to it, there was no basis on which the divisional court could have been justified in treating the process as unlawful. But she also held for good measure that there was no inconsistency between the linkage judgment and the position adopted before the divisional court by the Secretary of State. What the appellant now seeks to do is to reopen that decision on ground 3, and we submit that there is no merit in that application. And I start with a reminder to the court, and no more than that, of the height of the hurdle that has to be overcome in a case of this kind. There are perhaps 2 relevant authorities to bear in mind, and again, I'm sure they'll be very familiar to the court, but I can invite you to take them up if you want to. But so I just give you the references, and if
You
you'll
could probably recite them to you.
yeah, right. so it's De Mariana at paragraph 59, Court of Appeal, noting the highly restrictive scope of the rule. That's Supplementary Bundle of Authorities, tab 5, page 93. So there has to be truly exceptional circumstances which are required to engage that, and they must relate to the decision to refuse permission to appeal, not to the underlying judgment against which the permission to appeal is refused. So they've got to attack Lady Justice Andrews, essentially. There are 2 questions that have been identified by the Court of Appeal in Wingfield. See paragraph 66 in particular of Wingfield Supplementary Bundle of Authorities, tab 4, page 74. The first question is whether the judge who refused permission, quote, grappled with the issues raised by the application for permission, or whether they wholly failed to do so, grappling question. If the issues were grappled with, second question, in doing so, whether a mistake was made that was so exceptional, such as wholly failing to understand the point which is clearly articulated, which corrupted the whole process, and where but for that error there would probably have been a different result. So not merely a quality of error thing, but also a no different result thing. And we submit that there is no prospect of the appellants overcoming those tests. We submit, first of all, that no different result, pick that point up from Winfield, even if Lady Justice Andrews had taken a different approach to the procedural injustice ground, it's impossible in the light of her rejection of the rationality ground that a different outcome would have been reached. So that's a complete answer straight up. But there is no prospect of surmounting the quality of error or the failure to grapple elements of that test. And we do respectfully submit that there is no difficulty or procedural unfairness in any event. It might be thought self-evident from documentation that the process that had been followed was detailed and thorough. It wasn't a sine qua non of a detailed and thorough process that one went through all of the methodology that may have underlain analysis of whether particular incidents in Israel were or were not, or in Gaza were or were not in violation of international humanitarian law. So that isn't a sine qua non of a fair and thorough process. Clear from the documents, therefore, that is exactly what ultimately happened, and clear also that it was self-evident that in the context of military operations by a foreign state, a friendly sovereign state, no doubt, but a sovereign state anyway, the ability of an outsider state to start addressing in any detail or in any degree of adequacy whether or not particular incidents breached the well-known principles of international humanitarian law was going to be extraordinarily difficult. You'll be well aware what those tend to be. They tend to be disproportion, not respecting civilian population, and all the rest of it. But in order to work out whether a target was a legitimate target and so on, you need access to a whole bunch of things that you're never going to have in the context of military operations being conducted by a foreign state. So the idea that the divisional court alighted upon was self-evidently correct, which is that there were bound to be limitations on all of that. But fundamentally, the reasoning was the reasoning that Lady Justice Andrews identified, which was that this wasn't a case in which you could possibly say that there was a need to start going into the methodology or undermine, seeking to re-investigate all the ways in which that side of the balance worked. What the Secretary of State did on advice from the Foreign Secretary was to accept the recommendation that Israel was not committed to compliance with international humanitarian law. That was an extraordinarily serious conclusion in its own right. It didn't need further development of the detail of that in order to place that as a very significant weight into that side of the scales. The difficulty from Al-Haq's point of view is that the other side of the scales had a thumping great weight in it as well, and a weight which plainly outweighed those other matters, because the consequence of withdrawing from the programme, which would have been the only way of preventing parts for F-35s from reaching Israel and being certain to do that, would have been to undermine critical elements of the defence of this country and of the maintenance of international peace and security across the globe, which in large parts, particularly through NATO, depended upon the ability to keep serviced F-35s and to keep them in the air. And that was the finding of fact that the Divisional Court made. We respectfully submit, therefore, no need to start getting sucked into the sort of nuancing, balancing exercises that my learned friend referred to, and no vice, procedural or otherwise, in the Divisional Court referring to the clear and thorough process that was undertaken before the decisions were ultimately reached. They were self-evident from the Mensas, and the detailed analysis that underpinned them. So, for all of those reasons, we respectfully submit that there was, in fact, no procedural injustice, no errors by Lady Justice Andrews, but that's to treat the matter as an issue of substance for you, which it ain't. See the case law. Did she grapple with them? Yes, she plainly did. Did she go so badly wrong as to undermine the entirety of the process? You can't just pretend that what you say was a slightly different view of the world amounts to that sort of error. We respectfully submit, therefore, that there's no prospect of the appellant being able to surmount this test. My ladies, my lords, I'm sorry I've gone a bit, but that's what I wanted to say on the issues before you. I've had a bit of a discussion with Mr. Wordsworth as to whether or not he has anything to add. He may have nothing to add. He may have something to add. Can I leave him to tell you whether he does or he doesn't?
Be in suspense for at least 5 seconds.
Well, unless there's anything else I can help you with, I'll pass over. Thank you.
Thank you. Yes, Mr.
My ladies, my lord, I think it's a question really whether I can assist you on this issue of whether there was in fact a dispute as to the relevant customary international law principles, which my learned friend Mr. Samuel spent quite a good time on. So if I can help you on that particular issue, if that is troubling you, in addition to the points that Sir James has just made as to why these rules, if they were rules, should not be received into custody international law, then I can make some brief submissions on that issue.
I think we think, is there anything you feel you have a burning desire to add?
That's very kind, my lady. I think the answer to that is probably not, because the essence of the dispute, for example, on Article 1, is so clear from the judgment, and an attempt was made to say today, well, some bits are accepted as to what Common Article 1 means, others are not. There's that differentiation between negative obligations and positive obligations. If you actually go to the judgment of paragraphs 47 through to 51, then you can see very clearly what the debate is there. It's got nothing to do with positive and negative obligations. It's to do with the question, in effect, whether you should be adding into the wording of Common Article 1 new words. If I ask you very quickly to turn to paragraph 47, where Common Article 1 is set out, you see it says there, the high contracting parties undertake to respect and to ensure respect. And the words that Al-Haq chooses to add in here, in effect, in its interpretation, are respect by all contracting parties for the present convention in all circumstances. Hence, you can see this from the next para in the judgment, it is saying that there's an obligation on the UK to ensure respect for the conventions by Israel. And that's a massively controversial issue. Does it have this outward-facing meaning? And that's really the critical content of the principle that they are putting forward. And quite correctly, the divisional court is identifying that as a matter of dispute. In fact, it's a highly controversial matter. And one can see that from the identification of the Secretary of State's response on this issue at paragraph 49. And the UK does not accept that Common Article 1 can be read in this way, and nor indeed to various other states, and listed there one has US, Canada, and Israel.
And what about the paragraph 53 point that was of the submissions in the Russian case that you were referred to?
And it's an entirely different context. So that is where Russia is saying to the International Court, Article 1 of the Genocide Convention is engaged. And therefore, we have a right under the Genocide Convention to stop the genocide on Ukrainian territory. So it is positively putting forward a case that Article 1 is on the table, completely different to the case here. And the UK in that situation is saying, well, if you are going to say Article 1 is engaged, you cannot do that in a way that is abusive. You have to have looked at, you have to have conducted a due diligence exercise and the like. That doesn't assist you at all, so far as concerns how the Genocide Convention is to be applied in this case. If we're moving on from Common Article 1 to the Genocide Convention.
And are you able to help with paragraph 133?
My Lord, yes, I think in two. My Lord, do you mean 131, the content issue?
Well, it's 131 and 133 because on one face they appear to be sort of internally inconsistent.
I think perhaps particularly with Common Article 1 in mind, what the court is doing is to saying, okay, we accept that there is a sort of a shell here called Common Article 1, which has this wording. But the question is, does that wording give effect to something sufficiently solid that it can be received into customary international law, that it itself can represent customary international law? So, for example, with regard to Common Article 1, you'd have to be the principle that Al-Haq is asking for incorporation of is Common Article 1 in effect with these words added into it. So that's how I understand the issue. And of course, there are massive issues as to the meaning and the way that you can identify whether or not there is a breach of the Genocide Convention. It's a matter of huge debate in front of divisional court. You heard some of that this morning as to whether there is some international law concept of being inconsistent with that could be relevant. Whereas we say very firmly, it's a question of breach or not breach that could not come out more clearly than from the Bosnian genocide case. Your references to the ILC articles on state responsibility had nothing at all. And if one looks a little bit further in that bundle, what one sees in fact is it's stated in terms. International law does not distinguish between terms like in conformity with, consistent with, in breach of. It looks at them in exactly, they're treated as synonyms. So we say that doesn't help at all. And
so you say they're firing at the wrong target, do you, when they say that it's all a question of duty, that the duty is arisen regardless of whether there is in fact a genocide or there has in fact been a breach? That's, you say that's an incorrect analysis.
It's an incorrect analysis, my lady. Their case it's inconsistent with. And they're saying that comes back to the self, inconsistent with is sufficient. But then when one actually looks at the wording of the self, when it uses that term, inconsistent with, and then there are various provisions, including a reference to the Genocide Convention, it's quite clear that it is actually talking about in breach of. So that's the target it has to aim at, and it can't get round that. And one could actually test that by reference to the act that Sir James just took you to, As you recall that he referred there to section 9495 and how that referred in terms to a table as to what the guidance only could be concerned with. And then at, I think it's number D of the table, it's referring to breach of such and such international law, breach of international human rights or something like that. It's not about consistency with some sort of bizarre term which doesn't exist in a relevant way so far as the SELC is concerned, and does not exist in any way, the relevant way as a matter of international law.
Anything else? Mr. O'Brien, anything? Anything? No. Mr. Hussain, do you need us to rise for a few moments?
Fine, thank you. You're very kind, my lady, and I'm sorry
No, please
for
don't
the
apologise.
disruption I've
No,
already
you haven't.
caused.
You
My lady,
disrupted
I'm
us
going
at
to,
all.
thank you again. I'm going to go first, if I may.
Of course.
Then Miss Martha. So,
So just remind you both that we are now into reply, not
Of
the
course, of course,
argument,
of course.
and we've read a lot. And
indeed, my lady. I will not be very long at all. First point, my lord raised a question regarding para 1112.
Yeah.
What if on ground one, Miss Kaufman wins, I don't? Compelling reason, we say absolutely yes, that is a proper basis for the appeal to proceed. Compelling reason, obviously, an alternative to a real possible justice. So I think my lord gave straight permission to appeal in the Gaza family Article 8 case out of time on that basis. So it's an alternative. It doesn't make sense to say, well, you've got to have a proper case. So we resist that. And of course, I must remind you, the test here is permission to appeal, a refusal of permission to apply for judicial review. So,
therefore, was it arguable at whatever level?
yeah, technically, there's a multiplier effect, but let's not, we doesn't have to be silly about it. Was there an arguable case?
Yeah.
Then ground one, 8 very short points. They are short. Firstly, my Lady Justice Whipple, your ladyship said ground 6 wasn't before the court. That's true. What that means is that if the test is tenability, we can't get home on ground 1. I accept that, but we say that's not the test. See our skeleton at paragraph 24. Second point. So James cites the famous authorities, Tin Council, etc., on dualism. The foothold issue via policy is not offensive to dualism, and the principle that, save in the colonial law context, in the case of proclamations, the executive can't make law, because policy is not law. It is indicative rather than dispositive of rights, so you can have good reason to depart from it. No dualism problem. Third point. So James starts with what he describes as a finding of fact, that the SELC as a whole was departed from. That turns on what was meant by the invitation to, quote, depart from the SELC in the 30th of August ministerial submission from Mrs. Pratt. That, we say, is a legal question, but even if it's not, we say the divisional court's treatment of this was plainly wrong. The reason it was plainly wrong, I'm going to come on to. Fourth point. Sir James referred to the ministerial statement of the 2nd of September, that this was, the carve-out was a specific measure in a specific case. That's page 630. Except you can look at it. I don't want to take time off that for various reasons. We thought about it. But that just means that the Minister, that the Secretary of State is departing from the SELC. It doesn't tell you what he's departing from, whether he's departing from the bill or all of it. Fifth point. Sir James made submissions on the July MinSub, the 24th of July. He rather glossed over paragraph 9, where it is stated in terms that to remain lawful, you have to have compliance with all of the other criteria in SELC. licenses must continue to be compliant with all underlined the criteria in the SELC to remain lawful. That's page 76.
Court supplementary bundle.
Supplementary tab 4,
Yeah.
page 76.
Thank you.
6 points. So James then made submissions on the 30th of August, min sub, from Mrs. Pratt. Again, paragraph 13, we say, is critical. It cannot be finessed away because that paragraph provides the key context for the carve-out. You'll remember that, again, in similar terms, paragraph 13, page 83, tab 6, supplementary says, whilst this submission focuses on C2C, licenses must continue to be compliant with all the criteria in SELC. And it is very clear, as a matter of logic, we say, that what follows from all of this is that the departure was from C2C. Why is that? It's clear that the suspension was based on C2C. That was the criterion that was in play. Secretary of State's position was, her advisor's position was, everything else is fine. International law is being complied with CSC1. The F-35 carve-out was a carve-out from that suspension based on C2C. Therefore, the carve-out required a departure from C2C. It didn't require departure from anything else, and nor was there a departure from anything else on any reasonable approach to the documents. The skeleton below, I've already given you the references to where Sir James, in terms, stated that there was no departure from criterion 1. That the references were his skeleton 220.9 and in particular 223.1, the F-35 carve-out was also premised on the basis that licenses were consistent with other criteria in SELC. Did not say it was disapplied, at least there. Last point, my 8th point, is conspicuously Sir James, with respect to him, says nothing about the complete lack of evidence. We've just been debating what Mrs. Pratt meant in her min stuff. She gave evidence in 3 statements, didn't say that at all. It doesn't address the illogic of saying that a good reason for departure from one condition means that you've got good reason for departing from all conditions. As I said, that amounts to a policy change, not policy departure. And the last thing Sir James says nothing about is the whole point of policies generally a fortiori in this very formalistic context, where you've got to publish before Parliament, explain your position before Parliament. Is a commitment to robustness and transparency. This approach does not promote that at all. If the Secretary of State was departing from all the SELC, all the criteria in SELC, he ought to have made that completely plain at all junctures, rather than relying on Sir James's advocacy. There's a limit to what that can achieve.
Come on.
Very wide limit. But this is beyond the outer limits even. Ground 2, 5 points. Sir James says on ground 2 that it is hopeless to suggest that the court got the test wrong on reception, but we say that paragraph 131 is indeed a muddle. I think my lord talked about the internal inconsistency. There are 2 internal inconsistencies we respectfully submit. Firstly, the assumption.
Wait, just a moment, let me turn it up.
Sorry, 131, page 106.
Thank you.
This is the first of my 5 points. We say there is a muddle for 2 reasons. Firstly, there's an assumption that the obligations are CIL, but then they're thrown into doubt. I see the force of the court's observations that they might be referring to core versus periphery. But at lines 3 and 4, what you do have is a clear statement that that's not to say the content of the relations is clear, so as to satisfy the very demanding test for reception in the common law, not for constitution of the norm as custom. The second point I wanted to make is that both the duty to prevent genocide and CA1 are still, very unhelpfully, the Secretary of State below reserved his position on that. It's quite an extraordinary way, we should respectfully submit, to present their case. And perhaps that's why there is what we say a bit of a muddle here. We addressed the customary status of both CA1 and the Genocide Convention in our skeleton below, tab 8, core bundle, pages 256 to 260. As regards Common Article 1, we cited at 284 the Nicaragua judgment, both as regards respect and ensure respect, it says it's CIL. We cited at 286 ICRC commentary. At paragraph 287, we cited Rule 144 of the ICRC study. At paragraph 288, we cited practice. As far as the Genocide Convention is concerned, we cited at 291. Why? Based upon the reservations case and the Bosnia case, right? The duty to prevent is customary. The prohibition is jus cogens. The duty to prevent is customary. As far as the Genocide Convention is concerned, Mr. Samore addressed you on the court's judgment at 132 and the fact that and the idea that it's important not to conflate two aspects: the extent to which a state is required to take action, that is addressed in Bosnia, para 40, authorities 3, tab 42, page 1835. The extent to which a state is required to take action, very clear in that passage. And then what action to take? That's simply an application of the law to the facts. It's not a basis upon which not to receive a norm. Mr. Wordsworth says, I think he called this touchy-feely below, the distinction between inconsistency with a norm and breach of the norm. But today it's bizarre, below was touchy-feely. There are two answers there. The first question is, if that's right, when does he say that the duty to prevent genocide arises? Is it when there's a genocide? Which gives interesting results for the concept of prevention. It's absurd to say that the duty to act only arises when there's the funding of genocide. It's absolutely the case that there's a distinction here, for the reasons Mr. Summerall gave, between a distinction between a breach of the duty and conduct inconsistent with it. But the position is completely clear in the statute. There's a sort of a fairly light touch attempt to justify by reference to the statute. And it basically founds on this. Mr. Wordsworth says that if you look at the table, the schedule, the table in the schedule refers to breach. I think the term is contravention. Yes, it does. But I need you to ask you to take that up very briefly. I'm sorry to ask you to do that at this time, because
where are we looking?
You're in authorities tab 1. This is the Act, and the table is that paragraph, page 18. Well, I should probably start with the schedule paragraph 2, which is the previous page, page 17. You have that at the bottom of the page. Export controls may be imposed, etc. In relation to any goods, exportation on use of which is capable of having a relevant consequence. And then over the page 3.1, for the purposes of para 2, a relevant consequence in relation to any activity is a consequence. And then these are the words that have to be glossed over by the Secretary of State, direct or indirect, of a kind. Wide words. And then you've got the concept of contravention, I accept, at DB, acts contravening the international law of armed conflict. I think that is just IHL. Now, that doesn't just stand alone, because if you look at section 9, you again see the width of what is contemplated. These are wide words. Paragraph 9.4b, page 12, the guidance required must include guidance about the consideration, if any, to be given to issues relating to any possible consequences of the activity being controlled that are of a kind mentioned in the table. So it's not just breach or contravention that's contemplated, and then the SELP, we say, draws that distinction. As far as Common Article 1 is concerned, this, as Mr. Samora accepted, there is a debate between what they mean, but we can, for the reasons he gave, we can get home on respect. We don't need ensure respect. See our amended statement of facts and grounds, page 509, tab 11, paragraphs 204 to 205. Mrs. Moore referred you to the Verity Robson article 33, tab 58, page 2114 and 2124. Third point I wanted to make, third of my 5 points, dualism, again, not a problem here. The reason it's not a problem here is because the executive can't easily make law simply with another state. See Freedom and Justice Party 117, Judgment 125. The policy of the common law, quote, is that it should be in alignment with CIL. That's the position as a matter of binding authority. This court, Freedom and Justice Party, paragraph 117, and CIL rules have a generally beneficent character. Judgment 128, Lord Debenture, Lord Lloyd Jones, who one might think knows a bit about this subject. Generally beneficent character, policy is to be in alignment with the CIL, so no problem with dualism, we say. Fourth point, Sir James raises an inter rorum argument, the idea you're going to have masses of international law somewhere taken in if our argument is right. There's nothing to that, as you might expect. You have to get into CIL first, very demanding test, as you know, and then there is a presumptive shaping of existing common law. The presumption is that it's received, that it shapes. That's the term used by Lord Madison, KU. It shapes existing common law, absent an overriding reason why it should not. Fifth point, the idea that Parliament has made choices. I'm afraid to say here that Sir James's submissions were heretical. The question is whether or not Parliament has occupied the field, not whether it's entered the arena. As I said before, in opening, we get that from KU Lord Mance at paragraph 151, Authorities 116, page 558H.
You're a bit too quick there.
Lord Mance in KU at 151, Authorities 1, tab 16, page 558H, and Lady Justice Arden in FJP at 125, paragraph 125, page 1047C. Exclusive code. Question is, has Parliament purported to create an exclusive code? As Sir James accepts, the preventative duties are not enacted by Parliament. Does that mean that there's some sort of implied exclusion of the ability of the court to receive the preventative duties? Absolutely not. There's a very famous example of this, which the court will be familiar with, particularly my Lady Justice Whipple, given her experience in SIAC. If you think of Belmarsh number 2, you've got section 134 of the Criminal Justice Act criminalising torture, and the House of Lords admit into the common law a flanking obligation which supports that. You can't receive the evidence derived from torture. It's an adjectival flanking obligation that supports the core obligation. The fact that Parliament has enacted the crime isn't somehow a reason why you don't admit in common law something that is a CIL law. And so the position, there's an analogy here. And then the last point that Mr. Sir James made, the idea that the Act, the ECA Act, undermines our submission. Not at all. I can say it one very short phrase. Every point that Sir James made conflates and confuses CIL with international law. If you think about the difference, very different imperatives are in play. Unincorporated international law, dualism, Parliament's entered the field, indication the courts shouldn't develop or interpret the statute in a way that aligns with unincorporated international law. Position is completely different when you've got a higher status law. Those are my submissions.
Thank you very much. Ms. Kaufman.
We're grateful to the court for sitting beyond 4 o'clock. It's been a long and it's a difficult day. These are difficult.
It's been a long day for all of you, so
I'm not going to be long. I'm going to start with ground one, the parts I was dealing with. And the starting point with that, and we say the end point, is a Sir James' assertion that there is a well-trodden, well-established non-jurisdiction of non-justiciability, whereby, in some contexts, based upon the subject matter of the issue of the case, the court was simply not tread. And it was notable how he failed to identify many, if any, cases in which this well-established principle had been established, addressed, discussed. In fact, he identified 3 cases. One was CND, one was Al-Haq, and the other was Abbasi. CND I dealt with this morning. Sir James said in relation to CND that it wasn't the case that the Supreme Court had concluded was a foreign act of state case, but I took the court to paragraph 130 of the judgment, which is the majority judgment in Belhage. That was established in the Jura, in a Supreme Court case, in the Law Debenture Trust. Both of those cases identified the Neuberger judgment, or Neuberger's judgment as the majority, and clear it is, because you can see who agreed with it. So I took you to 130. I'm not going to take you there again, but it's important that the court looks at it in terms, in paragraph 130. Lord Neuberger refers to the court in Norcan relying upon the court's judgment in Al-Haq, in the CND case, and specifically paragraph 47, little Roman numeral 2, which is the part of Lord Justice Simon Brown's paragraph 47, which deals with what are non-justiciability issues as opposed to domestic foothold. So it is quite clearly and authoritatively established to be a case on foreign act of state. So far as Al-Haq is concerned, I took the court to that this morning. I'm not going to go back to that and repeat what I said. And Abbasi, he didn't take you to Abbasi, and that's because Abbasi is not in the authority bundle at all. And it's notable, if we look very, very quickly at the defendant's case before the divisional court, which is at tab 9 of the commission, the core commission bundle, at page 19. I'm so sorry. No, it's tab 9. Tab 9.
tab 9 is the skeleton
Page
argument.
302 of tab 9. And here we can see the case, the various ways in which the defendant put the reasons why ground 8 was non-justiciable. So the first was domestic foothold, in the sense that the dualist argument, effectively, there's no legal basis for policy or what have you. And then, that's 31, the arguments about that are set out above, so 31 is just the concluding paragraph. And however, there are 2 further independent and self-supporting reasons why it's not justiciable. And we have paragraph 32, it trespasses onto matters of high policy. And here we have reference to Al-Haq and CND, and no reference whatsoever to this other rule that has now been articulated by reference to a battle which is not before this court, of a long-standing established principle where the subject matter means that the courts will not tread. And I remind the court that we are dealing here with an application for permission to appeal a commission decision. My Lady Justice Whipple asked whether in paragraph 112 of the Divisional Court's judgment it was really only going wrong by trying to characterise this rule of non-justiciability as an issue going to domestic foothold. We strongly submit no. That was one way in which it went wrong, but where it went wrong more fundamentally is by identifying the rule of non-justiciability as one that exists at all, independently in foreign acts. Sir James said of paragraph 88 through to 90 of the Divisional Court's judgment that they were alive to the distinction between non-justiciability and deference, deference being the approach the court must take in relation to issues of national security. I'm not going to take your lordships and my ladies back to that, but quite clearly what happens in paragraph 90 is that the court conflates the two and derives from the conflation a principle of non-justiciability, not deference, not discretion, but non-justiciability that incorporates matters of national security that are ones which the courts have been absolutely clear for a long time are issues of deference. Can I just add in relation to my Lord Justice Dingemans' point about whether or not there might be a compelling reason to grant permission even if the court is against us in relation to the second ground of second basis on which ground one is put. That is the error of the court in finding that there was a departure from the entire SELC. This is obviously, this ground that I am arguing is obviously a matter of very, very significant importance. Is there, in fact, more than one basis upon which a court can conclude in this terrain that matters are non-justiciable, or is it just foreign act of state? And that is something which this court, in our submission, should certainly grapple with if this court thinks it is arguable that the divisional court went wrong, and that would therefore provide a compelling reason in relation to the other ground. Now I turn to ground 5. Sir James has been uncharacteristically unfair, I would submit, in the way that he has dealt with this point. We were all there in the court below, and there is no question that when we presented our arguments to the court, both in writing and in the introductory moments when Mr. Hussain addressed the court, there is no question that we presented our clients' views about what is going on and what had been going on in Gaza. And those views were expressed with the fullness with which they are felt. So yes, we did present that case, their view, that what is going on in Gaza is a genocide. But at no point, as Mr. Samore showed you this morning, and what he showed you this morning was purely a replication of how the case was put in the court below, at no point were the views of our clients presented as the factual basis upon which ground 8 was argued. The entire case was run on the basis of risk in the manner in which Mr. Samore has explained to the court this morning. So whatever's there in the skeleton argument, whatever was said at the beginning of the hearing, did not feature as a basis of as a basis on which the court could find that our case required the court to determine that Israel was in fact violating IHL as opposed to was at risk of violence. IHL. And it's notable, if the court looks at paragraph 56 of our skeleton, or rather at paragraph 122 of the divisional court's decision, which is on page 101 of the permission bundle, the first response that it doesn't accept, that first response is that it was not part of our case, that the court is going to be required to determine the legality of Israel's conduct. And at 122, the court says in terms, we would not accept the first of these responses. The claimant has insisted that it is an important part of its case that Israel has committed and is committed genocide. See footnotes 10 and 62, and you will see that those refer to the way in which we presented our client's beliefs, while the lawfulness of Israel's conduct under international law is at the heart of the case. Well, it was only at the heart of the case in the sense that the risk of a future breach was at the heart of our case, for the reasons that Mr. Samur has given. We didn't need to go as far as saying there was illegality on the part of Israel, and we didn't go so far as to say that. Now, we did try and get a transcript of the divisional court's judgment, and unfortunately, for some reason, the recorder did not pick up much of what was said, and in the end, we were told it was not sensible to do so. So we now have two slightly different characterizations of what happened, but the claimants did not at any point argue that it was necessary to determine the legality of Israel's conduct. And that was why we argued the Foreign Act of State ground on the basis that we did. Precisely because the arguments we had presented were not ones which required the court to determine the legality. Can I turn to the second point that Sir James made in relation to paragraph 122, and that was the Nor-Khan point, where in Nor-Khan the court had said, well, even if there wasn't a determination of the legality of Israel's conduct, in this case, in that case the US's conduct, that's what it would look like to them. Now, in my submission, that's actually really a fourth rule of Foreign Act of State example. It's about embarrassment. It's about how it looks. It would embarrass us because it would look like that. Whereas, in fact, as a matter of strict judicial determination, it isn't that. Well, we've seen how that fourth rule has been doubted. He took you to Lord Sumption on this. Lord Sumption is not the majority judgment in Belhaj. So that observation of his takes the defendant nowhere. It was simply an observation that Lord Sumption made in relation to why it was.
Well, I think Sir James accepted that when it was queried by Lord Lodge.
I think what he said is it's very difficult to find where the majority is, but it's actually not difficult to find where the majority is. The majority is in Lord Newberger's judgment. But in any event, that is not part of the majority judgment. And this really is an aspect of...
I think he went on saying he didn't need it anyway, but let's not at this time of night start
having an argument about it. Yeah. So our situation is, in fact, exactly the same as the way in which, or the matters that the court had to look at in Law Debenture. There they were looking at the facts of duress, not having to make a determination about the legality of duress. Here, the court is having to look at the risk of illegality. It's exactly the same sort of situation.
Thank you.
So
now,
finally,
you are in reply, so I'm giving you as much leeway as I can.
I'm grateful. It's just he did come to Law Debenture, so I'm just replying on the Law Debenture point. So finally, then looking at CPR 5230.
Well, have you anything to add? We've got your arguments on that.
The only point I'd make is that he tried to draw some sort of distinction between what the divisional court found in relation to the process rationality because of the difficulties that were experienced and some overall conclusion in relation to rationality. In our submission, it is intimately and integrally connected to the overall finding of irrationality. And that's really the only point I would make on that. So unless we can help further, those are our submissions.
Sorry, Judge, just wanted to give you one reference by way, it's not quite rejoinder, but it's by way of correction. My learned friend said Abassi isn't in the bundle. She's right about that. What is in the bundle, however, is the Al-Haq #1 decision, which you've already been to, which is behind tab 12 of the authorities bundle. I just wanted to give you two references. The first one is to the submission that I made in Al-Haq #1, directly and squarely relying on paragraph 106 Roman 3, which was the one I referred to from Abassi, for the proposition that foreign relations could be a forbidden territory or forbidden area. The submission is recorded at 28 of the judgment, page 359, and that submission was accepted by the Divisional Court in the judgment of Lord Justice Pill at paragraphs 43 to 44, referring in terms to Abassi paragraph 106.
We looked at 43 and 44, didn't we?
We did, and that's at page 363. And in the skeleton argument to which you made reference, the passage from Al-Haq that we quoted included the reference to Abassi in paragraph 44. And that reference is in paragraph 32 of our skeleton below.
Well, thank you all very much. I was about to say, which I do maintain, that I'm very grateful for the considerable courtesy and respect that you've each shown until we got a little scratchy at the end during the course of this very important and difficult case. I'm very grateful to all of you. The immensely hard work that everyone on the front row has put in, but also I'll never forget the juniors and of course the solicitors and legal executives and the like who've worked so hard behind the scenes, and may I thank whoever's been putting the bundles together, and that for considerably less than their normal rate, to thank them for the exemplary job, because it's made a very bulky case much easier for us to find our way around, especially when we've been tight for time. You won't be surprised to hear that notwithstanding this is an application for permission to appeal, that we are going to reserve our judgments. We've always regarded this as an important case needing expedition, as you know, as we reference to when the actual divisional court hearing was. So we'll aim to get a result to you as quickly as we can. We will, notwithstanding the fact that it is a permission application, we still intend to send through a draft for typographical and minor infelicities, please not to re-argue. May I emphasise very strongly in a case of this nature the importance of the embargo. We must be told precisely who is going to see our draft, and those of you that know me know I will be extremely firm about that, having been very badly bitten in the past. So can I thank all of you very much indeed. I don't know if anyone has had childcare or other difficulties as a result of sitting late, but if so, I'm very grateful. Thank you all very much.
Court rise and able.